So no appearance for the claimant. How can you say Mr. Robert is not for this case? He's counsel representing the claimant here.
Mr. Roberts. My lord, is Hosanna.
Hosanna Robert.
Yes, my lord. Okay, I thought it's Robert Joseph Bassett.
Tell him to unmute himself now. Call him.
All right, my lord.
Now, what is
Yes. Appearance.
My lord, I'm sorry. Hosanna Robert respectfully appear for the claimant.
Okay.
Yes, sir.
Yes. Any appearance for any representation for the defendant?
My lord, MT Ibrahim used to appear for the defendant, but I do not know if he is in court.
So let's make progress anyway.
As God pleases.
I want to confirm the representations. What I have here is Emmanuel Etitop and Hosanna Roberts for the claimant. Am I correct?
My lord, I appear alone for the claimant. Hosanna Robert is my name.
So you don't want Emmanuel Etitop there?
No, my lord. My lord, he had long withdrawn his appearance.
Okay. If you say so.
God pleases.
MT Ibrahim for the defendant, correct?
Yes, my lord.
Okay. Next is, with your kind permission, I would like to go straight to my decision, given the fact that we have network issues here. So I will skip the case of the claimant the case of the defendant, reply to statement of defense, submissions of defendant, submission of the claimant, and go straight to my decision. Is that okay?
Yeah.
Good. So this is my decision. I've carefully considered the facts of this case as given in various processes, the submission of parties and the evidence thereof, and I will adopt the issues submitted for determination by the claimant. That is, whether from the evidence before this court, the claimant has proved his case to be entitled to the relief sought. Before the determination of this issue, it is imperative to consider the application by the claimant for the amendment of relief 1, relief A. Made in his final address to read, a declaration that by virtue of the provision of the human resource policies and processes of the defendant, particularly at page 160, the claimant as next of kin to his late wife is entitled to be paid the sum of 16.6 million as the retirement saving, which is the sum total of 396,000, which was her emolument multiplied by 3.5% instead of million naira paid. In support of this application, the as doing so will not lead to any miscarriage of justice or prejudice. Bring the relief in line with the evidence. The is that final address is not an avenue for this sort of application, and that it is too late in the day. This is the summary of the parties' position on this issue while adopting their final written addresses. The claimant application for amendment at this stage of the proceeding brings to the fore the question of when it is appropriate to bring such application and in what manner. It is settled law that the power of the trial court to permit amendment of the pleading is almost limitless, and this power will not be questioned unless it is shown that the trial court discretion was improperly exercised. See the case of Igwe and Kwalu, Pa Uthman Mohammed, Justice of the Supreme Court, and Gawan and Ike Okongo, Pa AI Kasina Alu, Justice of the Supreme Court. It is also the law that amendment of pleadings would be granted even at a late stage of the proceedings if the amendment does not take the other party by surprise or cause any form of injustice to the other party. This is Ahmadi and Thomas Aspin, Ogun Taimihin and Gabire, and Shell BP and Jamal Engineering, Austin and Sharaki, Igwe and Kalu. In line with the above principles of law, an amendment pleadings was made before judgment as in the case of Ukechukwu and Ohe, and Champagne and Idoreyin. The Supreme Court has also granted application to amend the statement of defense at the address stage in the case of Eta and Dazie. Pa S.A. Alago, Justice of the Supreme Court. An amendment can be granted as soon as the defect in the proceeding is detected and even on appeal. This is what Karebi White said on the issue in the case of Alson and Saraki. Notwithstanding, and I quote, notwithstanding this guide, an amendment may be sought and, if appropriate, granted on appeal if it is to amend the record of the trial court in line with facts proved before the trial court and the decision. This power is to be exercised to prevent the occurrence of substantial injustice. He cited Metal Construction West Africa Limited versus Miglogo and Karemu, Laguro, and Honsu, and another, and of course. Although rules of court provide that application for amendment should be by way of motion or notice, judicial authorities have shown that the manner of application is not closed. A case in point is the case of Eta and Edazi, where Alagu, Justice of the Supreme Court, said, and I quote, Order 26, Rule 2 and 3 of the High Court Civil Procedure Rules 1988 allow an amendment to be made at any stage of the proceedings for the purpose of determining the real questions in controversy between the parties. What undoubtedly appears worrisome in this matter is the late stage of the proceedings at which the application to amend the statement of defense was made at the address stage by counsel. But even this is allowed under the rules of court if it is not intended to overreach the other party. While evidence has been laid on a particular point through witnesses, an application to amend the pleadings to fall in line with the evidence so already given is not one intended to overreach. There is nothing sacrosanct in such an application being made orally. End of quote. In the light of the foregoing, it is my finding and holding that the defendant objection to the application to amend relief at this stage of final address is of no moment and therefore grantable, and I so hold.
As a God pleases, my Lord, we are grateful.
The next question is, under the circumstances of this case, is the application grantable? This calls for a close look at the amendment itself. The amendment sought here is the addition of the word instead of 5.6 million paid after relief aid. While the law is that an amendment can be made at any stage of proceedings, different considerations or circumstances may apply for the success of the application. Some of the considerations or circumstances are given by various legal authorities. While the grant does not necessitate the calling of additional witness, evidence, or changing the character of the case, or to prejudice will result from the amendment. No prejudice, will result from the amendment. While the application will not cause an undue delay in the proceedings or is not intended to overreach or ambush the appellant, as in the case of Okafo and Ekinyi and Eta and Edazi. While the amendment was sought in bad faith, or if the amendment, even if granted, will not cure the defect in the proceedings, Lagunjo and Abasi and Rajil Labi, How this condition played out in this case will determine the success or otherwise of this application. From the fact of this case and the evidence adduced, there is no evidence that this application was made malafide with the intention to overreach the defendant, change the character of this case, cause unnecessary delay, etc., etc. Instead, the proposed amendment is aimed to bring the pleadings in line with the evidence already laid so as to determine the real controversy between the parties. So from whatever angle one looks at it, be it the timing of the application, the manner it was made, or the circumstance thereof, the application for amendment is bound to be granted and is hereby granted. Now it is time to consider whether, from the evidence before the court, the claimant has proved his case to be entitled to the relief sought. The relief sought in this case are declaratory: payment of death claim in the sum of 16.6 million, general damages of 50 million, and cause of action in the sum of 5 million. The burden is on the claimant to prove he is entitled to all the relief sought, and because he is the one seeking for judgment on the existence of the facts which he asserted, the burden of proving those facts exists rests with him. In other words, he who asserts must prove. See Buhari and Obasanjo, Bayelsa and Rivers. Bayelsa and Rivers, Uwomilojo and Anibere, and Ikwegu and Nigeria. And these propositions are also the purport and tenure of Section 131, 132, and 133 of the Evidence Act. There is also the requirement that the claimant must do so on the strength of his own case and not on the weakness of the defense, subject to some exception. This is the case of AIC Limited and NMPC. Then there is Abimbola and Abata. To start with, relief A is declaratory in nature, and as such, the claimant must show the existence of legal right or a claim which the court is prepared to recognize as valid. This is the case of Olu and Ebite. Second, a declaratory relief cannot be granted merely on default of defense or even on admission, as there is no declaration without argument. In other words, the court does not make declaration of right either on admission or in default of defense without hearing evidence and being satisfied with such evidence. See the case of Kwajafa and Bank, Akino and Nezrim, Dim and Enomo, CBN and Amao. Having said that, whether or not the claimant is entitled to this declaratory relief depends on the success of the main relief, which is B, for payment of 1/6. Relief B is for the payment of 16.6 million as death claim for the claimant as next of kin of his deceased wife. The law is that in labor cases such as this one, it is the claimant who has the burden of proving his entitlement to the claim and the quantum of his claim in terms of how he came about the said claim. To prove an entitlement, the employee must refer the court to the exact provision of the law, instrument, or document that confers the entitlement. This is, see the case of Oyo State and Alaji Apapa and Mohammed Dungus and others versus ENL Consortium Limited. In other words, it is the duty of the claimant to plead only such facts and materials that are necessary to sustain the relief sought and adduce evidence to prove same. This is the case of Gabriel Active and Cable Metal Nigeria Limited. To decide whether the claimant has proved his entitlement to the death claim, it is imperative to evaluate the evidence by the parties in the light of these two requirements of entitlement and conduct. To prove entitlement to the death claim, the claimant tendered and relied on 14 exhibits. The first task of the claimant is to prove that his deceased wife was a staff of the defendant by tendering her letter of appointment, that is Exhibit 3, letters of promotion, Exhibit CW4, and letter of confirmation, Exhibit CW5. The second is to prove that the wife died. To this end, the claimant tendered the death certificate from the National Population Commission, Exhibit 6, death certificate from the Hospital Management Board, Exhibit CW7, newspaper advert, Exhibit CW13, condolence letter by the defendant, Exhibit CW8, and a notification of death by defendant to Trust Pension Fund PLC, dated 25th May 2016, Exhibit CW14. And to prove his entitlement to the death claim as well as quantum, the claimant exhibited certificate of marriage, letters of administration, that is CW1, human resources policies and processes, Exhibit CW11, and pay slip of the deceased, Exhibit CW12. While the fact that the deceased was a staff of the defendant and she died were proved without any further proof, the proof of the claimant of his entitlement and quantum thereof requires further scrutiny. The claimant referred to page 160 of the Human Resources Policies and Processes, that is Exhibit CW11, which provides, and I quote, in the event of death of a staff, the benefit is 1.5 years of the annual emolument of the deceased staff paid to the next of kin, end of quote. Exhibit CW12 is the pay slip of the deceased, which fixed the consolidated monthly salary of the deceased at 396,600 naira, thereby giving the impetus for the calculation of the death benefit payable to the claimant as 16.6. The combined effect of the Exhibit CW11 and CW12 has satisfied the requirement of the claimant to prove his entitlement and quantum of the death benefit. I have therefore no hesitation in finding and holding that the claimant has proved his entitlement to will be this far. The burden to prove otherwise is now shifted to the defendant. Apart from the testimony of the defendant witness in court, the defendant relied and tendered 3 documents, to wit, letter from Metric Insurance Nigeria Brokers Limited, dated 11 January 2016, that is Exhibit DW1, payment voucher dated 19 August 2015, that is Exhibit DW2, and reply from the defendant on the payment of full gratuity dated 8 March 2018, Exhibit DW3. The letter from the Metric Insurance Brokers Limited forwarded discharge vouchers of various staff of the death claim of 4 staff of the defendant under the letter from Metric Insurance Brokers Limited, Group Life Assurance Scheme, including the claimant, which fixed his benefit at 14.2 million. The payment voucher was burial expenses in the sum The payment voucher had burial expense in the sum of 865,000. Exhibit DW3 is denial of liability for any outstanding death benefit and insisting that the benefits of 20.6 million have been paid to the claimant by the defendants, trust pension brokers for burial expenses, retirement saving account, and group insurance. The defendant also relied on what it considered the contradiction in the claimant's claim, on the one hand, insisting of not being paid the death benefit at all, and also admitting to being paid the sum of 5.6 million out of the 16.6. Now, given the state of pleadings and evidence by the defendant, can it be said that the defendant has dislodged the entitlement of claim to the death benefit? I think not. The common denominator in the three exhibits relied on by the defendant is that none of them made reference to page 160 of the Human Resources Policies and Processes, which provided a death benefit of 2.5 years of annual emolument to be paid to the next of kin of a deceased staff. Exhibit DW1 only indicated the benefit payable to the claimant under the group life assurance scheme to be 14.2. On the other hand, Exhibit DW2 is a voucher for the payment of burial expenses in the sum of 865, without more. While Exhibit DW3, apart from denying any further payment of death benefit, only provided how much was paid to the claimant in terms of burial expenses, retirement savings account, and group life insurance. While the evaluation of evidence this far indicates that the claimant is entitled to the death benefit of 16.6, a further scrutiny raises some fundamental questions on the contour. First is the attempt by the defendant to lump the payment of the retirement saving account of 5.6 with the death benefit of 16.5. Apart from the incompatibility of the two benefits, the contention by the claimant that only 5.6 million of death benefit was paid does not add up, since it will reduce the amount sought. This is the apparent inconsistency the defendant was harping on. Second is the confusion created by the Human Resources Policies and Progress, Exhibit CW11 itself. At page 153, a staff insurance scheme which provided for group life policy, a policy for the compensation of the beneficiary of the assured person in the event of death. The scheme went further to provide benefit to be given to the next of kin at paragraph 7.5b as 3 times the annual total emolument per the provision of the amended Pension Reform Act 2014. This is the provision under which the sum of 14.2 million was paid to the claimant. At page 160, there is another provision to the effect that in the event of death of a staff, the benefit is 3.5 years of annual emolument of the deceased staff to be paid by the next of kin. The question now is, does the Human Rights Resources Policies and Processes Exhibit CW11, envisage the independent application of the two provisions in whose case, in addition to the payment of 14.2 million to the claimant, he will also be paid 16.6 million as provided for at page 160. This interpretation is obviously untenable because it will amount to double compensation, which the law frowns at. It is settled law that once a party has been fully compensated for the loss or harm suffered, it will not be open to the court to proceed to award any kind of additional damages that may look like a bonus. For to do this is to compensate a party twice for the same wrong complaint. See the case of Mabamije and Otu. Ogu and General Oil Limited rely on Alhaji Mustafa Aliu, Kuswa and United Bao Construction Limited. The only option left is for me to compare the two provisions given at pages 153 and 160 of the Human Resources Policies and Processes. And to choose which one will be advantageous to the claimant under the circumstances. The quantum of compensation to be given to the claimant as the next of kin at page 153 is fixed at 3 times the annual total emolument, while 3.5 of the total annual emolument was fixed as death benefit at page 160. The computation based on the interpretation of the provision of page 153 resulted in the payment of 14.2 million to the claimant, while the computation on the interpretation of the provision at page 160 will be 16.6 million. Since the full payment of 16 million will amount to double compensation not allowable by law, and since the claimant was paid 14.2, he is only entitled to 2.3 million, being the balance as death benefit. I am fortified in this choice by the principle of labor law that initiated in the case of Chiroma and Fort Oil, Awolade and Nigeria Aji, all delivered by Justice B.B. Kanye on 2nd May 2019 and 12 July 2016 respectively, to the effect that any ambiguity regarding the payment of any entitlement for an employee must be resolved in favor of the employee in the most practical and humane way. This principle of law was given judicial approval in the recent Supreme Court case of New Nigeria Development Company Limited versus Daniel Obabe 2020 is a 2021 case. Relief A, being a declaratory relief, is dependent on the success of the relief B. And since relief B only succeeds partially, the relief as presently called cannot be granted. Relief C, which is for general damages in the sum of 50 million against the defendant for waste of time, economical and psychological trauma, cannot be granted, since the award of damages of whatever kind are a function of liability, and the claimant did not establish saying the claimant cannot be awarded damages in that regard. See the case of Union Bank and Sores. Sokwa Motor, Sokwa Oil Limited versus Bank of the North. Relief deed for the cost of action in the sum of 5 million cannot be granted because the claimant cannot foist his cost of litigation on the defendant in the absence of any express agreement. See SDC and Okenonodo. It is also unethical and an affront to public policy for a party to pass the burden of his solicitor's fees to the other party in the absence, as in the cases of Guinness Nigeria Limited, PLC, versus Nwoke, Naji and Coastal Services, and Ehikoba and NCB Limited. For the avoidance of doubt, the case of the claimant only succeed to the extent that the claimant is only entitled to 2.3 million, being balance of the death benefit as the next of kin of the deceased wife, having been paid the sum of 14.2 million before. Defendant is hereby ordered to pay the claimant the sum of 2.3 million within 30 days from today. Judgment entered accordingly. I think I've lost them.
As a court, please, my lord.
Mr. Robert,
My
are
lord,
you
I've
there?
not,
Eh?
my lord, I've not seen him again.
So that is my judgment anyway.
As a court, please.
Yes. Gosh. Kaida red biro. Hello, Mrs. Okon.
Yes, my lord.
Next.
Okay, my lord. Suit number NICN UY35 2020 between Joseph Robert Bassi
Present in court, my lord.
and Akwa Ibom State University. The registrar, Akwa Ibom State University. My lord, the claimant is present in court. Defendant absent.
Representation. Appearance.
I am Chris William. My Lord, with proper respect, I am Chris William. My Lord, Chris William, holding the brief of Samuel Igbo Esquire for the claimants.
For.
My Lord, the claimants.
Yes.
My Lord, respectfully, the matter was adjourned to.
Let's see if there is representation for the defendant now. No representation for defendant.
Oh, my Lord.
No.
Yes, Williams.
My Lord, we respect the matter was adjourned to today for adoption of final written addresses.
Yes.
My Lord, respectfully, we have a motion on notice, my Lord, before the court.
Before you move the motion, have you served the motion on the defendant?
Yes, my Lord, we accept.
Mrs. Okon, any proof of service?
Yes, my lord, they will serve.
Any response from them?
None, my lord, I've not
My Lord,
seen.
there's no response. It's a harmless application, my Lord. My Lord, the reliefs on the motion paper.
Mm-mm. Don't jump the gun.
Lord.
Mrs. Okon,
Yes, my lord.
is there any indication that the motion is going to be reacted upon?
No, my lord, is the motion you asked him, the authorities you asked him to cite and file to you and also to the other defendant counsel. That's
Did I tell him? Did I tell him to
if
come by way of motion?
no, my lord.
Okay. Yes.
My Lord, respectfully, the motion was filed on the 8th day of April 2024.
On the
My Lord, 8th April, 8th day of April 2024.
yes,
My Lord, the motion is bringing this honorable court for leave.
pursuant to what order?
My Lord,
Pursuant to what order?
my Lord, pursuant to order 45, sorry, my Lord, order 45, rules 2,
Yes.
and rule 5 of the rules of this honorable court.
Seeking for
My Lord, for leave to file a list of authorities inadvertently omitted in the final written address.
yes,
And also for new authorities that were discovered after the filing of the final written address, which are applicable to this case, my Lord.
yes.
Now, the motion is also praying the court to deem,
Hmm?
my Lord, to deem the authorities and the new authorities, my Lord, already filed as said as proper. And for any other or further orders, the court may deem fit to make it.
Yes.
Another respect, support of the motion is an exhibit of 12 paragraphs. Is an affidavit of 12 paragraphs, my lord, deposed to by the claimant.
Yeah. Come again.
My lord, the support of the motion is an affidavit of 12 paragraphs. Deposed to by the claimant, Dr. Joseph Robert Bass.
Yes.
I also have a written address in support and only pray my lord should grant the motion. No, that's our own application.
In the absence of any objection and in the interest of justice, application for the submission of additional authorities is hereby granted as prayed.
As court cases.
Yes.
My lord, with my lord's leave, may we adopt our final written address. My lord, having at the close of trial, the defendant filed its final written address on the 4th day.
Did I give you the go ahead?
Sorry, my lord, I'm sorry.
What can you say about the absence of the counsel on the other side?
But my lord, we don't know why he's not here.
Lawyer's office downstairs. Lawyer's office is as you enter. The best room as you enter by the left hand side. You are not there. I'm in my office. Ask somebody where is lawyer's office.
Oh, Bishop, why are you disturbing me? You don't know I'm in court? Okay.
Williams.
Yes, my lord.
Can you go ahead and move your application? Can you go ahead and adopt?
Claimant final written address filed on the 14th day of March 2020. Filed on the 14th March 2024, my lord. As our final
14th March.
Yes, my lord, 14 March 2024.
Yes.
Our argument, and humbly pray, my lord, to grant all the reliefs sought by the claimants.
Yes.
And may we also pray that the defendant's final written address be deemed adopted.
Yes.
You so much, my lord.
The defendant's final written address, having been filed, is hereby deemed adopted.
And
And the
second,
case,
At all
and the case
places.
adjourned to 14 June 2024 for judgment. Defendants will
As a
serve
copy.
hearing notice.
Thank you, my lord.
Next.
suit number NICN UY 49/2020 between Mr. Gallant Basi Edet Eduno and Independent National Electoral Commission. My lord, parties are absent in court.
You said parties are absent?
Yes, my lord.
Appearance?
My lord, with profound respect, my name is Anietie Akpan. Lord, my appearance is for the claimant. My lord, we are very sorry for his absence. He's in the office. My lord, I'm on the road, sir. He's waiting in the office.
Yes.
Please, Your Lordship. My Lord, I appear for the defendants. My name is B.N. Chuku.
EN.
B.N. B as in ball. N as in Nigeria. Chuku. And I appear for the defendants, my Lord.
Yes.
Yes, sir. My lord, upon the receipt of the defendant's final written address, the claimant filed his final written address on the 20th day of May 2024.
Upon the
My lord, the set
receipt of
of the defendant's final written address filed on the 15th day of February 2024. My lord, the claimant filed his final written address on the 20th day of May 2024 with a motion to regularize the said process.
the claimant
Filed his final written address on the 20th day of May 2024. My lord, the said process was filed with a motion to regularize
again on the 20th
day of May, 20th day of May 2024. The claimant filed his final written address.
Yes, with a motion.
With a motion to regularize the said process. My lord, the processes were served on the defendants.
Yes.
Yes, my lord, we have not received any opposition to the motion or notice to regularize the process. And with the leave of court, may we move the said motion.
Please, who is talking? I can't see you.
My Lord, by Steinate Ekpan is the one talking, sir. My Lord, I said we had filed a motion or notice on the. Okay, sir.
Okay, move. Move the
Okay.
motion.
My Lord, we are grateful. Okay, my Lord, there is a motion or notice before this honorable court filed on the 20th day of May 2024. A motion or notice filed on the 20th day of May 2024.
Yes.
My Lord, the motion is praying the court for 3 reliefs as set out on the face of the motion paper.
Number one.
Number one, my Lord, is an order granting leave for the claimant applicant to file his final written address in this suit out of time.
Two.
My Lord, the second one is an order deeming the said final written address of the claimant applicant already filed and served as proper, appropriate fees having been paid.
Yes.
My Lord, the third one is for such order or further orders as the court may deem fit to make in the circumstances of this case. My Lord, in support of this application.
Wait.
Oh, sorry, my Lord. Sorry, my Lord. Sorry, my Lord. My Lord, I'm very sorry. And for such order or further orders as this honorable court may deem fit to make in the circumstances of this case.
Yes.
My Lord, in support of this application is a 7 paragraphs affidavit deposed to by Imabong Achibong, a litigation secretary in the office of the Claimant Applicant Counsel.
It was to buy.
Imabong Achibong, a female litigation secretary in the office of the Claimant Applicant Counsel.
Yes.
My Lord, we rely on all the paragraphs. And my Lord, in support also is a written address of counsel. We adopt same as our legal argument in support of this application and pray, my Lord, most respectfully to grant same the default fees having been paid.
Yes. Yes.
My Lord, that is our humble prayer before the court.
Chuku.
Yes, my Lord. I won't oppose the application, even though I have not received the process. That is an innocuous application. I will not oppose.
Application for extension of time is hereby granted as prayed.
As a copy, please.
Yes.
Milord, we've not received any reply from the defendant. I don't know if my learned friend had filed.
My Lord, we
Filed what?
have reply on point of law, my Lord. We did file our reply on point of law, although it was filed today, and the information I got is that it has been served on my learned friend.
I can't hear you, please.
As a copy, my Lord, I said, can my Lord hear me now?
Yes.
My Lord, I said that
yes, I can hear you now.
Yes, my Lord. Following the claimant's final address, we did file a reply on point of law, although we filed today. And the information I have is that it has been served on my learned friend at his office. He just informed this court that he is not in the office. My Lord, I was informed that we have served them at his office. If my learned friend would not mind, I can also forward the soft copy for him to go through. They do not have right of further reply, so that we can move on and adopt the address.
Mr. Akpan.
Yes, my Lord, I had informed the court that on the road, my Lord, they have not had a call from my secretary. But my Lord, I wouldn't mind if the court is minded to grant us leave to adopt our final return addresses. My Lord, I'm okay with that.
So you are agreeable to it?
Yes, my Lord. Yes, my Lord.
Yes, go ahead.
As the court pleases, my Lord, our final defendant filed its final address on the 15th day of February 2024. My Lord, we
Wait now. You file on
the 15th day, 15th day of February 2024.
Yes.
My Lord, we shall, in urging this honorable court to dismiss the case of the claimant, be relying on the said final address.
Yes.
Yes, my Lord, if my Lord would just 2 minutes to point out, my Lord, that
what do you want to say, counsel?
yes, my Lord.
Is it not in your final written address?
My lord, is just to point it out, even if it is 1 minute, my lord, because it appears to be novel in a kind of. Even my lord will appreciate when I raise I point out the issue, my lord.
Okay.
Yes, my lord. My lord, in these proceedings, my lord, we have stated in our final address that we observed that the claimant relied on 4 different depositions on oaths.
My lord, it is already captured in their written address. I don't know what he's trying to adumbrate.
My learned friend, I have
We
the
had
permission.
joined issues on that. We had joined
Mr.
issues on
I
that.
have
Akpan,
the permission.
Mr.
I have the permission
Akpan,
of
Yes, my lord.
he said he want to adumbrate and he asked
Oh,
for 2
yes,
minutes.
yes, my lord. My lord, I'm
And
sorry
I've
about that.
given him.
I'm sorry about that, sir.
as a couple. So, my lord, the claimant
He relied
filed
on
4 different depositions on oaths in arguing this case, in proof of this case, my lord. And how it happened was that the claimant, we noted that on the address, that the claimant would adopt his written statement on oath, and after adopting, he will apply to amend the written statement on oath. He will file another one, and my lord, in all, there are 4 different written statements on oath, and the 4 of them.
yes.
And the 4 of them, they contradicted themselves. My lord, we have pointed the contradictions. We quoted them in our final address. And we also cited authorities to the effect that the effect of such contradiction is that the entire evidence of the claimant are to be expunged. Because my lord cannot choose and pick which one to believe. My lord pointed them out. Yes, my lord. My learned friend has argued that upon amendment, that
Mr. Tuku,
I'm sorry, my
Mr.
lord.
Tuku,
Yes, my lord.
you have said I should give you 2 minutes.
As the court pleases, my
You
lord,
have
my lord.
said you have said all these things are reflected in your final written address.
As the court pleases.
So what is it again?
As the court pleases, my lord, I thank your lordship for the indulgence. My lord, we shall rely on our final address, and we will urge this court to dismiss this the claimant's claim with substantial cost.
Yes. Yes. Mr. Akpan.
Yes, my lord. Yes, my lord. My lord, the upon the receipt of the defendant's final written address, the claimant filed his written address on the 20th day of May 2024. 20th May 2024. My Lord, we adopt
File.
same. His final written address on 20th May 2024.
Yes.
Yes, my Lord, we adopt same as our final written address in this case. My Lord, we seek the leave of court for 1 minute, my Lord, to adumbrate on just one issue, sir. On the issue of issue raised by my learned friend, that there are 4 statements on oath, depositions before the court. My Lord, we had argued the said issue raised by my learned friend, stating the law that the law is trite, that once an amendment, that the law is trite, that once an amendment of the court process has been ordered, the effect is that what stood before amendment is no longer a material before the court and no longer defines the issues in contention. That once an amendment of the court process has been ordered, once an amendment of court process has been ordered, the effect is that what stood before amendment is no longer a material before the court. No longer a material before the court, and no longer defines the issues in contention. No longer defines the issues in contention. My Lord, the record of the court will bail us out that amendments were made in this case. My learned friend is now drawing.
Wait. Is no longer material and no longer
defines the issue in contention. No longer a material before the court and no longer defines the issue in contention once an amendment has been ordered by the court.
Yes.
My Lord, we had made an application, they equally amended, and we responded to the amendment. And my learned friend is still referring to those processes that are no more material before the court. My Lord, we had addressed that issue exhaustively. So we urge on my Lord to discountenance the submission of learned counsel for the defendant, and consider the written statement on oath, which we asserted the ones that are very material before the court. They are just 2. The one in the amended process and the reply to their amended statement of defense. That is the one that is material before the court. The other ones that were, the statement on oath.
What is material are the 2?
The 2 statements on oath of the claimant, which is the one that is filed alongside the amended complaint. The amended complaint. The one filed alongside the amended complaint, and the one filed as a reply to the amended statement of defense, which was ordered by the court.
One filed
alongside the amended complaint of the claimant. And the one filed as a reply to the amended statement of defense of the defendant.
Yes.
So, my Lord, we urge my Lord to treat the depositions of the claimant as being material evidence in support of his case and grant all the relief stated on the face of the complaint. My Lord, we have addressed all the issues exhaustively, and we urge my Lord to look at it and use them in determining this case in favor of the claimant. We so urge, my Lord.
Yes, Mr. Tuku.
Yes, my Lord, I'm grateful. My Lord, we did, after receiving the address of counsel, we did file our reply on points of law. It is dated 29th day of May, but filed on the 30th day of May, 2024. But filed on the 30th day of May, 2024. On the 30th day, today, my Lord, 30th day of May, 2024.
Yes.
My Lord, we shall be relying on the said reply on point of law.
Yes.
My Lord, if my Lord would permit me, I want to state clearly that my learned friend misunderstood, completely misconceived the law on amendment, my Lord.
No. You are not permitted.
As the court places.
My Lord, it is on this
As the
point
court
of law.
places.
It is an issue
You
of
are,
law.
you are replying. You
the
want
law.
to adopt. You are replying on point of law. Is that not what
Yes.
you want to?
My Lord, it is to the law that I want to reply on. He has told this court that he has made amendments, and once amendment is ordered, that whatever stood before the amendment is no longer existing. My Lord, the point we are making is that that does not apply to deposition, which is your evidence on oath. It doesn't. That will be, yes, my Lord. My Lord was cited. Yes, my Lord.
Mr. Tuku, is what you are saying not in your written address?
My Lord, we needed to point it out.
You don't have to point it out.
As a court places.
Unless you think I will not point it out myself.
My Lord is
I will not see it.
enough to point everything.
No.
Wanted to help my Lord to bring it
Don't
to
help
the
me.
fore.
Did I ask you?
As the court places. As the court places.
Mm-hmm.
My Lord, we shall be
You
adopting
you will be relying on the reply on point of law.
Yes, my Lord. And we shall be praying this court to dismiss the claimant's case with substantial costs.
Case is hereby adjourned to 14 June 2024 for judgment.
As the court places. My Lord, we are very grateful.
Hello, Mrs. Okon. Hello. Akirat. Can't find him. Hello? 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 Mrs. Okon, call the next case.
Suit number NIC UYO 2022 between Elder Dr. Joseph O. Eliezer and Utah Lee Nigeria Limited. Leading. My Lord, parties are absent in court.
Yes.
May it please your lordship, Assam Junior. My lord, I appear for the claimant.
Yes.
Respectfully, sir, my name is O.R. Oniyeson. My Lord, Oniyeson is Oniyesan, sir. I appear for the defendants.
Yes.
Yes, my Lord, the defendants have filed their final written address, albeit out of time, and we have a motion on notice to regularize it. The processes have been served on the claimant's counsel.
Yes.
Subject to my Lord's convenience, my Lord, we are ready to move our motion on notice, sir.
Go ahead.
Thank you, my Lord. My Lord, there's a motion on notice filed on the 29th May 2024, sir. And is brought
on the
29th May, sir. 29th May.
Yes.
2024. My Lord, brought pursuant to Order 57. Order 57, Rule 4, Sub 1.
Order
57. Rule 4, Sub 1.
Yes.
Of the National Industrial Court, Civil Procedural Rules, 2017.
Yes.
And under the inherent jurisdiction of my Lord.
Yes.
My Lord, the said motion prays for an order extending time within which the defendants' applicants may file their final written address. Time permitted to do so having elapsed.
Yes.
My Lord, it also prays for an order deeming as properly filed and served the defendant applicant's final written address, appropriate fees having been paid. My Lord, he finally prays for such further order or orders as this honorable court may deem fit to make, and for such further order or orders as this honorable court may deem fit to make in the circumstance. My Lord, there's an accompanying affidavit which has 8 paragraphs, deposed to by one Samuel Umore. My Lord, we rely on
How
all
many
the
paragraphs? How many
paragraphs?
paragraphs?
8 paragraphs, my Lord. 8 paragraphs. Deposed to by Samuel Umore. My Lord, we rely on all the averments on the written address. My Lord, we have a written address in support of the motion on notice. We have a written address in support of the motion of notice, my Lord, which we adopt as our argument. We adopt same as our argument and with humility urge my Lord to grant the application in the interest of justice.
Assam Junior.
Yes, my Lord. My Lord, we've been served with the motion. We have no objection, my Lord.
Application for extension of time is hereby granted as read.
Thank you, my
And
Lord.
Yes.
My Lord, we were only served with the defendant's final written address yesterday at about 6 p.m. Even though our address, we had tentatively finished the address, there were some issues that my learned friend raised for which would require specific response to and research for same. And so that's why we have been unable to file it before the hearing today. I'll be praying, my Lord, for a very short adjournment to enable us factor those issues and then file our final address, Your Lordship.
Yes. Can you suggest a date? Assam.
Sorry, my Lord, I was just trying to look at my diary.
Only Assam.
Yes, my Lord.
Any date from you?
My Lord, the 13th day is convenient to me, my Lord.
Of what?
My Lord,
The 13th day of June.
13 June is convenient, Your Lordship.
Yes,
I'm giving you people 14th June.
14th
As
June
the
is
accomplices.
as the accomplices. Okay, my Lord.
As the accomplices.
Just is hereby adjourned 14 June 2024 for adoption.
As accomplices.
As the court pleases. Thank you very much, Your Lordship.
I'm grateful, my
Thank
Lord.
you. Mrs. Okon,
Yes, my Lord.
that is the end for today.
Yes, my Lord.
Okay. In the
All right,
absence
thank you, my Lord.
of any other business, I'm signing off. Thank you.
Thank you. Bye-bye, my Lord.